So once again, if you'd head to the October participation, type in 3 significant points. And today we'll look at the controversy of the Supreme Court. The Supreme Court has a long history of being, sometimes ignored, sometimes at the center of attention. It depends upon the period of time. But when the country first began in particular, it was mostly ignored because the third article, if you looked at it, is incredibly brief. The intention was that the courts would grow with the country, and so they didn't want to put too many restrictions on it in Article 3. But the flip side of that is that Congress really didn't pay too much attention to it in the beginning. The federal court system was not that detailed. It didn't have that many levels. It didn't include that many judges. And Supreme Court justices, as I mentioned, I believe earlier, they had to also serve as circuit court judges and ride out to the countryside. And they didn't have their own headquarters, and they didn't have a big budget or anything like that. And so there was actually a high turnover rate for earlier justices on the Supreme Court because they simply didn't want the job that much. In fact, the first Chief Justice, John Jay, who helped establish some of its precedents, is more well known as the guy that George Washington sent over to set up additional economic treaties with Britain, Jay's Treaty. So he's more well known for that than he is as the Supreme Court Chief Justice. And it really wouldn't be until John Marshall became Chief Justice that the Supreme Court started to get some more teeth behind it. And that's, of course, is the first time that it actually became controversial. Marshall was a Federalist, and so he believed in a strong central government. And he also believed in the elastic clauses of the Constitution. For instance, in the Constitution, it says Congress can do anything that is necessary and proper. Well, that's pretty expansive and vague. It can mean if they felt we all needed ice cream, they could just buy it for us. So he believed that allowed the Congress to have an expanding role in a variety of areas such as the economy. So in some of the cases that would come before him, he is going to favor the federal government over the states, for instance. But, of course, none of that would be able to happen until one of the cases that was mentioned in the bell ringer, Marbury versus Madison. Marbury was a man who had been promised by the Adams administration, the outgoing Adams administration, a job as a lower federal judge. And he was never given his commission papers, the papers to officially get his job. The new administration had a Secretary of State by the name of James Madison, and he realized that Adams was attempting at the last minute to hire all of these Federalist judges, and he didn't want to go along with it. He said, well, we just got sworn in, we're the new administration, so we're not going to honor Marbury's appointment. So Marbury sued Madison and went to the Supreme Court. And under the Judiciary Act that had been passed by Congress, it gave the court the ability to give Marbury his job. Well, the Supreme Court argued, we really don't have that role. It's not in Article 3. And so even though we agree he should get his job, we don't have the powers to do that. So they declared that part of the Judiciary Act unconstitutional. And so that set up the power of judicial review, which was controversial at the time because it didn't really say that in the Constitution either. It doesn't say that the Supreme Court can decide constitutionality matters, but basically that's implied. Why else would you have a Supreme Court to begin with? And so using that, he is able to uphold federal laws that give the power to the national government to make a national bank, for instance, which isn't in the Constitution, but it's under the Commerce Clause that it's implied. They also allowed the federal government to supersede states in giving out licenses, like in the case of steamboats in the Ogden case. And they also upheld that governments have to honor the contracts. They can't get out of them, just like private parties. And this was considered controversial because it seemed like he was just upholding the Federalist agenda in particular. But it set up an important precedent that would continue and also be resolved by the Civil War, that the federal government supersedes the states, especially because of the Constitution, particularly the 6th Article, which has basically a supremacy clause saying that indeed the federal government is supreme through the Constitution. After he passes away, the court enters another passive period, or period where it's being ignored in particular, except for one incredibly controversial case that would go along with the trio of controversial cases involving equal rights. And those three cases would be Dred Scott, Plessy, and Korematsu. So let me just briefly mention each of these. The Dred Scott case involved a slave by the name of Dred Scott who is traveling with his owner to a free state, and in that state, just to make it a long story short, his owner passed away. And so Dred Scott sued for his freedom, basically saying, hey, we got here, I'm here in this free state, so therefore I shouldn't be a slave anymore. James Buchanan, the president at the time, who was incredibly incompetent, encouraged the Supreme Court to take up the case, which he really shouldn't have been doing because that kind of crosses an ethical boundary, hoping that the Supreme Court would resolve the slavery issue forever and he would never have to hear about it again. Well, he should have realized, of course, that the Chief Justice Taney and a number of his peers were slave owners. They were obviously never going to rule in favor of Dred Scott. And in fact, they went further than that. They not only ruled that Dred Scott could not sue because he was not white, but they also said that property right was guaranteed in the Constitution. So therefore, not only did he didn't have the right to ask to be freed, but they also brought into doubt the fact that some states were free states because they were basically saying you couldn't own people. They were taking away people's property rights. And that the compromises that Congress had made, the Missouri Compromise, the Compromise of 1850, were all unconstitutional. And this added to the tinder fire that had already started over a variety of other issues and added to the complexity that would cause the Civil War to occur. The second of these trio cases would be at the end of the 19th century, beginning of the 20th century, Plessy versus Ferguson. After the Civil War, even though the 14th Amendment had been passed, setting up that everyone has equal rights and they can only be taken away with due process, a large portion of southern states, but also some places in the north, had enacted Jim Crow laws enforcing segregation. And the Plessy case involved a man who wasn't even, I think maybe one of his great-grandparents was African-American. And he rode on a train in Louisiana. He was actually hoping to get in trouble because he wanted to contest the idea of segregation. It went to hold of the Supreme Court, and once again, more conservative members who didn't want to rock the boat basically said that as long as you have separate yet equal facilities, it was okay to have segregation. And of course, as we know now, that actually never happened. Often facilities were substandard or secondhand, and so this was never intended to actually be carried out. And the last case would be Korematsu, and this case involved Japanese internment. Japanese American who had been forced to leave his home sued because he said his 14th Amendment rights, and 4th Amendment rights basically said that he didn't have the right for his property to be taken, he didn't have the right to be removed. And so this went to the Supreme Court, and the Supreme Court agreed with the federal government at the time that it was a national security issue and that Japanese Americans had clear and present danger to the United States. Of course, there was no evidence of this. There are lots of German and Italian Americans living in the United States. And by the end of World War II, not only had no Japanese Americans committed an act of sabotage, there was actually a number of Japanese Americans that served valiantly in the military. So Korematsu, Plessy, and Dred Scott were three of the most controversial cases that the court had decided. But this went along with the idea of judicial activism. Judicial activism is when a court goes beyond the scope of the original case. So, for instance, in the Dred Scott case, really the only issue should have been, was Dred Scott free or not? But they went beyond that and decided to look at the broader scope of the law. So that would be an example of judicial activism. It's a mistake because a lot of people say that only liberals or Democrats are judicial activists, but obviously it can also work in the opposite direction as well. And judicial activism would especially come into role when Chief Justice Earl Warren came into office in the 1950s. He was appointed by Eisenhower. He was the Republican governor of California, and he, during World War II, had gone along with Japanese internment, so a lot of people thought he would be more conservative. But it turns out that he was quite the opposite. In fact, one of the first cases that he helped rule on was Brown versus Board of Education, which actually reversed Plessy, citing that no separate facilities were ever equal, and therefore it had to be gotten rid of in education, and of course later on that would be expanded to others by civil rights legislation in Congress. But they also included from a judicial activist point of view on a variety of other issues, including expression, such as freedom of religion in particular. There are a couple different cases involving that. One was the Engel case, which is spelled Engel, and this involved school prayer because that used to be a common practice in the United States. But the Engel family sued over that, and of course it went to the Supreme Court, and the Supreme Court agreed that you couldn't have a scheduled prayer in particular because it's going to end up favoring one particular type of faith, maybe the majority that live in the area wherever it's conducted, and therefore it violated the First Amendment. And there was also the Abington case that involved Bible reading, because that also happened a lot in schools in the United States. At the beginning in the morning during homeroom, for instance, a Bible reading would take place throughout school buildings, and Abington's case sued over that and went to the Supreme Court, and they also agreed that that cannot happen as a mandatory practice of the organized school district, because that is a form of government. And speaking of expression, it also got into areas of freedom of speech, or maybe even the right not to participate in certain forms of freedom of speech. The West Virginia State Board of Education case involved Jehovah's Witnesses that believed that they didn't have to stand up and salute the flag during the Pledge of Allegiance, and the Supreme Court ended up agreeing with that. And later on, after the Warren Court, Texas versus Johnson, Johnson was a man who had burned the American flag in protest, and so he, of course, got in trouble for that and arrested and fined by the state of Texas, and so he sued Texas over this. Texas returned the lawsuit, and it went to the Supreme Court, and the court agreed that flag burning is a form of symbolic speech. And so all of these cases, of course, made the court seem like they are out of touch with Americans and traditional values, and so it became incredibly controversial. They weren't really major campaigns, but they were noticeable efforts, protests to impeach and remove Chief Justice Earl Warren, for instance. But of course, that didn't happen. He served out the remainder of his tenure. And the other issue that they would get into would be rights of the accused. In particular, before the mid-20th century, it wasn't uncommon for law enforcement to not have a warrant, to not let you talk to your attorney, to try to force you into confessing. Those are actually pretty common practices that occurred throughout the United States. And so there were a number of cases that the Supreme Court, starting under Earl Warren, took up that were controversial. Many people looked at it as being against law and order, being against the police. And so people didn't think too much of these cases at the time. But for instance, they included the Gideon case, which said that you, in fact, have to allow someone to have an attorney, because before that, that wasn't necessarily guaranteed in most cases, which occur at the state level. And so Gideon reaffirmed that you do have to, in fact, have an attorney. But then, just to show you why sometimes it's necessary for judicial activism to take place, that ruling was very narrow. And so police started letting people have attorneys, but they wouldn't let them talk to them. So, for instance, they would let them sign up for them, but they keep them in two separate rooms. So another case happened a year later by the name of Escobedo, and it was exactly that. Escobedo got an attorney, but he wasn't allowed to talk to him. And so that went to the Supreme Court, and they clarified, yes, you do have to let them talk to their attorneys as well. And then an additional case that went along that was the Miranda case, which included, of course, a man maybe of lower mental capacity that had been accused of rape. And he had been arrested and eventually confessed, not knowing, of course, that he had the right to remain silent or to an attorney. And so the Supreme Court went even further and said you have to tell people that those are their rights. So that's why when you are arrested now, you're given those rights that you've probably seen in TV shows and movies. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, people will provide you with one. So now we are read our Miranda rights. So they are named after an accused rapist. Although, don't worry, he got his justice. He was later stabbed, I think, in a bar fight. So anyway, those cases basically made it look like we're giving up on law and order and we're descending into anarchy. So a lot of these cases were controversial at the time. Of course, now, today, we expect to get an attorney. We expect to be read our rights. So it's not that big of a deal. And then, of course, the last issue would be privacy, which was probably a controversial topic that continues to this day, because privacy, first of all, is not in the Constitution. It's implied there in the Fourth Amendment, which says that the government has to have a reason to search and seize, like a warrant, for instance, or probable cause. The Ninth Amendment says we have unnamed rights, and there's a few other places you could draw it from. But basically from that, in the Griswold case, the Supreme Court said that, for instance, you have the right to get a prescription for birth control from your doctor. The state can't make that illegal because that's a private decision. And later on, that was expanded to Roe versus Wade, saying that people could terminate their pregnancy if they wish to, because once again, that is a private decision between their doctor. And obviously, Roe versus Wade continues to overshadow the court, because that's the question on everybody's mind every time a new Supreme Court justice is nominated. Will they be in favor of overruling that previous decision, or will they uphold it? And the last thing I want to mention, of course, is equal rights versus religious rights. And this is something that's come up especially since the gay marriage case several years ago. A couple of the justices on the Supreme Court right now have said in a forum that they spoke at that they believe that religious freedom has been endangered by, for instance, making people recognize something like gay marriage. So the thought is, of course, is if they get enough allies in the Supreme Court, they won't overturn gay marriage, but they would basically say if you work at a courthouse, you don't have to process the marriage license, for instance. If you have a small insurance company, a property insurance company, you don't have to recognize a gay couple if they want to buy home insurance, for instance, or things like that, because that is their religious right to stand up for their faith in the Bible that gay marriage or homosexuality is a sin, and therefore they don't have to cooperate with homosexual couples in any of those respects. On the flip side of that, though, if you are a recent immigrant from Saudi Arabia and you open a driving school and women come there to go get a driver's license, should they also be able to say, no, that's against my religion? So the concern, of course, is that could open a Pandora's box of other issues as well. So that's just some of the controversy involving the court and why those nomination processes that we talked about before can often take up a lot of news and a lot of frustration.